Good morning. We will call this case. This is State of Kansas, Appalachia v. Antoine Moliere, appellant. Case number 128223 from Lyon County. Will counsel for the appellant please state your appearance?
Antoine Moliere appears through counsel Jacob Nowak of the Appellate Defender Office. If it's all right at this time, may I please reserve 3 minutes of my time for rebuttal?
Granted, 3 minutes. And for the appellee,
May it please the court, your honors, State of Kansas appears by Ashley McGee, Assistant Lyon County Attorney.
let me get the spelling of your last name because you are a different name than what appears on my docket. What is your last name?
McGee. McGee.
And is G capitalized?
Yes.
Okay. Ashley McGee.
In your bar number.
And your bar number, please.
27911.
Got it. All right, very good. So 3 minutes for rebuttal, and the appellant may proceed.
May it please the court? Trials involving young children often have a certain tension in them because there is a natural tendency for people to want to make these proceedings as easy as possible on the children witnesses, but that has to be balanced against the defendant's constitutional right to a fair trial. And one of the reasons we trust jury verdicts as much as we do is because we afford defendants the meaningful opportunity to test the allegations against them through the crucible of cross-examination, which is particularly important in cases involving child witnesses because there's oftentimes very little significant evidence of the criminal activity other than the testimony of the children for a variety of reasons, which makes it incumbent for defense attorneys to be able to have a meaningful opportunity to form that reasonable doubt through the cross-examination of these child witnesses. But can we say in this case that Mr. Moliere was given that reasonable opportunity when one of the children at issue couldn't testify without her mother sitting right beside and alleged coach sitting right beside her during her testimony?
Was she beside her or sort of back behind her?
My understanding it was beside, maybe a little bit behind to the right. Obviously, we can get a diagram in the record, but that they described it as behind, so it wouldn't be necessarily in the child's field of vision.
Right.
And then where the other child couldn't maintain a distinction between reality and their imagination for the 20 or so minutes while they were on the stand.
But was there any real impediment to cross-examination?
I think I think to both children, yes, there is. I'll stick with LM for for TM, the boy, it's a little bit more straightforward in that it's really tough to cross-examine someone when they've slipped into that imagination, and all of their responses to defense counsel about how or why they know what happened is, I'm a robot, I can launch imaginary drones, I can scan through walls. There's not much that you can reveal about what that child actually saw or knows from that type of examination.
That was apparent to the jury as well, correct?
That the child was slipped into an imagination. Yeah, I mean, I don't think it's necessarily apparent precisely.
How does that impair your ability to cross-examine? I mean, a witness is a witness. I mean, how they perform is evaluated by the jury. What was it that was impeding a cross-examination?
Well, the problem with the child witnesses in these cases is that regardless of how they perform, the state's still going to be able to present the CAC interview. And the juries are going to be able to rely, at least in part, on that. So if the child isn't able to meaningfully participate in the trial process, then if their testimony isn't going to be considered strongly by the jury one way or the other because they say, it's a kid, they were just imagining things, then that CAC interview becomes all the jury relies upon, and that's pretty much a step away from trial by affidavit, because there's no way for the defense attorney to meaningfully contest the statements made there.
And there's no easy way for the state to prove its case if you've got a child witness like that. I mean, you have what you have, isn't it? I mean,
I've seen it be pretty easily proven through the CAC interviews when the children just get up on the stand and say they don't remember anything that happened. And that's sort of a backdrop of why TM's testimony is problematic, because we weren't able to meaningfully engage with him while he was up on the stand. As it pertains to LM and how the mother sitting next to her impeded cross-examination, I think you could ask pretty much any CAC interviewer, SANE SART nurse, or certainly any defense attorney who's ever done juvenile defense work, and they'll tell you that if you want to get the full story from a child, you need to speak with them outside the presence of their parent, because More often than not with these kids, obviously the allegation in this case is a full coaching, but more often than not, these kids, when they're speaking to their parents about events, they're going to at least omit, if not fib, about certain circumstances related to the event because they think that their parent might be disappointed or upset if they learned about those specific circumstances. It might not have all that much to do with the actual allegation, but it colors the events and is important for the jury to hear. Well, if the kid who's been talking with their parent or about the event for, the year leading up to trial has been omitting those certain circumstances and events, they aren't going to all of a sudden become forthright at trial if their parent is sitting right next to them or even in the gallery looking at them. And to that point,
Let me stop you. So we're talking in generalities, so let's focus on the facts of this case. So in this case, the motion for a support person was granted, but there were strict rules. Are you alleging that the support person violated any of the rules that were set by the district court?
I don't really know what the strict rules were. I think that the state had made a comment that they had
Well,
them not to interact and
it was where the support person could sit, could not move, could not comment, could not react. I mean, they're
Sure.
all in the pretrial order, very strict rules on the participation. So I guess I'm struggling to see how the court abused its discretion in allowing the support person
sure.
if this person didn't violate any of those rules and simply sat there. How is that an abuse of discretion?
It's because they didn't abide by the procedure in Dayhuff and conduct the investigation that would have been necessary before allowing the person to sit as an emotional support person. You're correct. There was no evidently active coaching that was taking place or violation of those rules during the jury trial itself. Our contention is that the mere presence of the mother would have continued to produce this coach statement, which is what was alleged below.
But in Dayhuff, I mean, that case was an active coaching situation where the
Sure.
court had to stop and get to the bottom of it.
Mhm.
So in this situation, why would the district court think it needed to stop and investigate if there was no evidence of active coaching?
Because you had a formal allegation of coaching by an officer of the court. And I don't think that necessarily Dayhuff is drawing a line that it's only circumstances that are taking place inside of the courtroom. For instance, if a defense investigator saw active coaching going on in the hallway right before a witness got on the stand, surely that would merit an investigation by the district court.
So is it just the inconsistencies of statements that you think triggers an what is it that triggers the investigation?
Is it
then?
just the fact it's the child's mother?
It's a part of it's the child's mother. It's the formal allegation by the defense attorney. They did support it with the inconsistencies. And so to that end, I think it is very similar to a justifiable dissatisfaction claim in that the court, not defense counsel, is going to be in the best position available to conduct the investigation because the people who know whether or not the coaching took place is going to be the alleged coach, the mother, and the witness.
Is there any
And
case law linking those two very separate areas of law? I mean, you're talking about when a defendant believes there's a conflict of interest with their attorney. How do we get from there to a judge's duty to investigate coaching?
no, I don't think there's any. I mean, Dayhuff really hasn't been analyzed much in the, at least in published opinions. There are a couple unpublished opinions I did find where the court did conduct a thorough investigation, and then we're in abuse of discretion land, which that's again very similar actually to the justifiable dissatisfaction claim. But the reason I think the court needs to be the one that's doing this is because again, it's going to be the coach and the witness who are going to be the only people who really know what happened. And that's going to limit a defense attorney's ability to actually conduct an investigation into it because the mother doesn't have to talk to the defense attorney, and they certainly don't have to let their child talk to the defense attorney beforehand. And I do kind of like the process of raising it at trial for that because if you, for instance, if you were to notice it up for a hearing and subpoena all these witnesses, assuming it's true, then you're just giving the coach, who has still a measure of control over that child, time and opportunity to coach them for that hearing as well. Well, here's what you need to say when the judge asks you these questions.
I want to
Well,
go ahead.
Sure.
I'm sorry.
Well, The judge looked at the motion, which was raised timely.
Yeah.
And then he looked at the facts, whatever the inconsistencies were that were alleged, facts that this is the mother, and looked at the law and then made a ruling. Why are we not reviewing that for an abuse of discretion?
Because, I mean, because DeHuff says conduct an investigation. I don't think you can conduct an investigation without talking to the parties that are involved. I mean, any finding, for instance, I don't think the judge actually, from my view, made any findings. But any finding they would have made about coaching wouldn't have been supported by substantial competent evidence because they didn't talk to the mother. They didn't talk to LM to determine whether or not there was any measure of influence that LM had exerted over her prior to trial or prior to the CAC interview that she gave. That's what you need to do before we can really review any sort of findings the court makes. They have to go through some measure of process.
Is there some authority that you have to make us assured that, yes, in fact, the judge does have to speak to these people individually before they determine?
I cited
motion.
various cases that talk about the judge's responsibility to actually exercise a discretion and what that requires. Again, we've got the justifiable dissatisfaction claim, which says you have to actually conduct some inquiry. Monclaw talked about how there's no.
I mean, in this
ability.
context of coaching the witness.
Well, I guess I'm relying on DeHuff because that is the only published case on this matter. And in that case, the court took issue with the fact that the district court didn't produce any sort of investigation during the allegation, and then even took issue with they waited 7 months, allowed that investigation to come in and conducted it at the sentencing, but they said at that point it was too stale to really be meaningful to determine whether or not there was coaching involved. So to your question, I'm relying on DeHuff, and to the extent that DeHuff doesn't extend as far as I'm arguing it does, we're making that argument based on comparable cases that we think.
I want to
are-
make sure we leave time to talk about TM in
Sure.
his testimony. So I believe you're alleging a Brady violation. Tell us about that.
Yeah, so the NAPU v. Illinois is the state's duty to advise the court and the jury that false testimony was presented. That is a subset of a Brady violation, which takes us out of contemporaneous objection land. We don't have to contemporaneously object to any Brady violations because, I mean, frankly, those are typically, we're looking at the bad acts of the state. And also, most of those are discovered after trial and before sentencing, and that's where they're raised. Now, granted, it wasn't raised in this case, so we're purely discretion on the court of whether it's going to review it. But given the record we have in this case, there's no additional facts that need to be found to determine that that was a false statement.
But you're
And-
not claiming now that it was perjurious statement.
Because I don't need to prove the child's intent, I'm not claiming it was perjurious. I think it probably the state's characterization of it as the child's imagination slipped in
Mhm.
is true, but that's a problem. I mean, we're talking about a trial for a life sentence, and we don't know where this kid's imagination began or end. He says he saw the event one of two ways. Either he's a robot who was able to scan through the wall, or he saw it through a little crack in the door that evidently is still there when the door is completely closed. There's pictures of those doors, and the police didn't identify any crack that exists. So can we really confidently sit here and say that the whole thing wasn't imagined? A product of the mom saying, hey, this is what you saw, and the kid rationalizing it in his head is like, oh, I must have seen it because mom says I saw it. That must mean I have some sort of power to see it.
But doesn't that all just go to his credibility that the jury determines, as with any witness who seemingly tells something that they have a hard time believing?
No, because when the prosecution has a duty to ensure that they're not presenting false or perjured testimony. So when it is apparent that the testimony, and I'm sorry, I do see I'm over time.
And you can answer.
So when it is apparent that the witness, whether child or an adult, has falsified testimony, and then they don't correct it when they're challenged on it, the prosecution has some duty to correct that and ensure it's brought to the court's attention.
But the defense counsel kind of take the ball and run with it with this kid. I mean, kind of exploited his testimony to prove a point. Does a prosecutor have a responsibility to stop that?
No, I mean, I think defense counsel was trying to make lemonade out of the lemons that he got. But
Because this came up in his recross correct?
Well, it
If
first came
defense
up during
counsel's question-
redirect. It was the prosecutor asked, how did you know when they were done? And the kid said, I think it was, well, you know how I can launch imaginary drones? I can also scan. And the prosecution goes, okay, no further questions. And then recross started to happen. And then more of then essentially was nothing but robot. And I can scan through walls at that point. But yeah, it's twofold. I mean, obviously, defense counsel tried to use it to their advantage, but it needed to be brought to the court's attention because, frankly, I mean, there is an issue of whether or not that child was competent to testify at all based on the language of the statute. And so that's what needed to be evaluated.
Tk you.
Thank you for your
You'll still
time.
have your full 3 minutes.
I appreciate it.
Counsel for Appley? You may begin.
May it please the court. This case comes down to semantics. Both issues can be resolved by taking them in the context in which it was given. Issue 1 with regard to the district court did independently assess the merits of the motion at the jury trial. The entire discussion of the court supports that it did in fact make an independent review. The court did not simply shut the motion down. The court did not say, I'm not going to hear the motion. In fact, the court allowed both the defendant and the state to have an opportunity to state their positions on the motion. The court took its time in deciding where the mother was going to sit. It determined the age of the witness and whether in going through those non-exhaustive factors of Rochelle, the court did do that. It considered the age of the witness. It allowed both parties the opportunity to suggest an alternative. And in fact, Moliere objected to even an unaffiliated adult sitting next to the witness. The logistics of where the person was seated, the availability of items, the use of child-friendly terminology. Ultimately, the state had filed motions with regard to the child-friendly terminology and child-friendly items, but given LM's position, the comfort item that was going to be sufficient to allow LM to testify was her mother. The state did propose a cautionary instruction and did in fact caution the mother as to what she would do when she sat there. And the record supports that the court took that into consideration. Ultimately, the court's ruling was that he was not going to overrule the prior judge. That comes down to semantics. While he said he was not going to overrule the prior judge, does not mean that he did not take the motion into consideration. And so I think ultimately, when
So you think there was a judgment on the merit?
correct.
The court considered the arguments and simply, unfortunately, didn't say, he just said not overrule.
That is the state's position, that he did an independent assessment on the merits of the motion and came to the same conclusion that he was going to allow the mother as a support person at the trial.
I want to ask you a question about our rule in something of this nature, because we aren't conducting a trial. We are only looking at a paper record. And of course, this is serious charges, life sentences involved. Ultimately, we have to decide if this was a fair trial. Was this a fair trial?
Absolutely.
Did this mother coach this witness?
There's
Any evidence of that in the record?
no evidence in the record that the mother coached the witness. There was nothing raised at the time of the jury trial. And in fact, Judge Larson, when he agreed to allow the mother to sit there, made a statement that if he were to see any type of coaching behavior, he would have stopped the jury trial and addressed the mother.
Can we rely upon that? Or it seems to me that the defendant is arguing it's the appearance that bolsters the testimony of the child, just the fact, the whole drama. Is that how you understand the argument?
That's how I understand the argument. I do not believe that's sufficient. That is not evidence. The evidence in the case does not support that there was any type of coaching. And in fact, when the defense counsel raised this coaching allegation, he raised it as that's his defense. It was not an officer of the court telling the court that he had evidence before him that he's presenting to the court that coaching was in fact happening and he was aware of it. He was merely passing along that the defense in the case is that these witnesses are coached, and that is the reason why they are saying what they are saying.
We often talk about discretion of the trial court to conduct the trial. Is this not clearly an act of discretion by the trial court?
Absolutely. That is the state's position that the trial court did in fact utilize its discretion in reviewing not only this motion as to whether the mother could sit with the witness, but he exercised his discretion in determining whether there was any proper coaching allegation before him and whether he had an independent obligation to investigate this raised issue. And
Let's stop there. That's a good point, and talk about Dayhuff. So the appellant believes that under Dayhuff, the district court had an obligation once the idea of coaching was presented to it. So he presented it as an officer of the court, made the district court aware. I think your characterization's a little bit different, that he presented it as his defense, but nonetheless, under Dayhuff, what duty did the district court have to investigate a claim of coaching?
I don't believe there was an active allegation being presented to the district court at the time. The jury trial had just started and we were taking up the issue of whether the mother could sit with the witness. The court was not being presented with an affirmative allegation that coaching had been occurring in the jury trial before it. I think had the court been presented with this is an ongoing coaching issue, the court may have then been more persuaded to stop and investigate. But given the information and the facts that it had been presented, there had already been testimony at the preliminary hearing. The court had already heard evidence before it, and there was no evidence at that time that there was an ongoing coaching that was occurring.
So it was simply a defense position that had been presented through prior hearings. But at the trial, there was never an objection, Your Honor, coaching, or nothing was brought to the district court's attention.
That is correct. And so
Okay.
the state's position is at that time, the court, in exercising its discretion, which it did, it heard the arguments of counsel, and at that time ruled that it was not an issue that needed to be addressed at that time, but if the court were to see during the trial any type of coaching behavior, any prompting of the witness, any emotions on behalf of the mother, that the court would stop and intervene at that point.
And the court gave a limiting instruction to the jury about the mother's presence.
Correct. And what's interesting is the children went first. The mother had not testified. So at the time that the children are giving their testimony, the jury does not know who this person is that's sitting with the witness until the mother later testified in the trial. So at the time that TM and LM, which by the way, the mother didn't sit with TM and TM went first, but at the time that the mother then sat with LM, the jury had no clue who she was at that time. And ultimately, with regard to whether the court abused its discretion in allowing the mother, the affiliated person in this case, this is not a one-size-fits-all. I know counsel alluded that children, when they need to speak, they don't speak with their parents present. But actually, the record supports that in order for LM to properly give her testimony, the state had taken that into consideration and learned that in order for LM to testify, she needed her mother to be present. Shifting then to the testimony of TM, again, this comes down to semantics, and ultimately the state's position is going to be that counsel is asking this court to make a factual leap, and what is actually not supported in the evidence. Ultimately, TM's testimony was not to a material fact. And TM did not tie his ability to perceive the incident to his claim that he was half human, half robot. And he did not say that he could scan through walls. The testimony of TM was, when asked, how did you know that they were done? And his response was, well, like drones, I can scan. I can scan. It's an analogy. And there's nothing before this court that tells this court exactly what he meant by I can scan. Neither the state nor the defense followed up on how he tied his ability to scan to his ability to perceive the incident that was occurring before him. His statement simply was that I can scan. When he is then later asked by defense counsel on recross, and so the state wants to point out that this was on recross examination. This was the defendant's witness at that time. He asked the question, and he actually asked the question in a manner in which he thought the witness would take as a joke. He took the witness out of reality and into his imagination by asking the question, how much of you is a robot, or can you just do things like a robot can? At that point, the witness didn't answer immediately, and defense counsel said, I'm joking with you. I thought you would laugh at me. And at that point, that's when TM said, well, as a matter of fact, I am half human and half robot. And when they started engaging in this discussion about how robots interact, the defense attorney did not stop and redirect the witness back to reality. The defense attorney did not follow up and ask the witness how he was using his robot abilities to perceive the incident. And in fact, the record actually supports that the witness testified more than once and had told multiple people before testifying in court that he did not use his robot abilities to see the incident, but rather he was looking through a crack in the door. And counsel says that, well, there was no supporting evidence that says he could see through the crack in the door. The witness testimony is evidence, and that is the evidence that is before the court today. There is no further evidence that TM used his robot abilities or scanned through walls. That's not what he said. He said, I am half human and half robot. And I think if you take that statement in the context in which it was given, this was not to a material fact. Counsel cannot make this become a material fact by taking it out of that context and asking this court to do so. That is a speculative inference that he is asking this court to do. And while the court can absolutely make reasonable inferences from the evidence, this is a speculative inference and would not be permissible for this court to do. And I think it also is important to note that while ultimately the state has an independent constitutional obligation as it relates to a duty to correct perjured testimony, this was not perjured testimony. It was not to a material fact.
And let's pause there. How are we defining perjured testimony?
I find this interesting because in the reply brief, counsel alluded that NAPU is the controlling law. It's the Supreme Court law, and NAPU is a 1959 opinion that used the term false. Kansas cases that have taken into consideration NAPU, that have addressed it, use the word perjured. And that is a notable distinction because false takes out intent. Perjured takes intent into consideration. In the Kansas cases, like State v. Betts that was cited in the state's brief, use the word perjured, and Betts specifically cited to NAPU. So Kansas, when adopting NAPU, used the word perjured. A conviction obtained by the introduction of perjured testimony, then the prosecution had the duty to correct what it knew to be perjured. And
by that you mean intentionally,
correct.
There was an intent to deceive.
Beyond just a false statement, the state needed to know that it was both false and that the witness was intending to make a lie to the court and to the jury.
What evidence do we have in this record that we can form the opinion that the child intended to deceive?
Absolutely. It's not what we know. We as adults with reason and science can say TM is not half human, half robot.
Answer my question. What evidence is in the record is there that we can conclude this child intended to deceive?
Absolutely. There's nothing. There's nothing in the record to show that TM knew by saying he's half human, half robot was a lie. That is not in the record. Nobody either followed up on direct examination or cross-examination whether he knew the difference between the truth and a lie as it related to that question. He was specifically asked on cross-examination, what part of you is a robot, or can you just do things that robots can do? He was taken out of reality on cross-examination into his imagination. And what defense counsel thought was going to be a joke, the witness thought it was an opportunity to talk about something fun, because this is hard to talk about.
Can we infer from this record the child was just playing?
I do not believe, to some extent, when he was prompted to talk about robots, he went with that. But can we infer that he knew that he was talking about a lie and that he knew what he was doing was false and intentionally false? I do not believe so. What did TM know at the time that he made that statement? That's what matters, and that cannot be shown in the record by either side.
Go ahead.
This is categorically a different type of statement than any case examining perjury, correct?
That's correct.
To your knowledge.
That's correct.
And along those same lines, where do we find the requirement that the perjured testimony must be related to a material fact?
Can you ask that again?
So why do we have the requirement that it must be a material fact? So, he's going on and on, but why is it important that his testimony must be related to a material fact to be perjury?
So that was the state's main argument in this case, is there's no question it was a false statement. And even if TM didn't know or knew it was a false statement, regardless, his statement was not to a material fact. His statement about being half human, half robot was not to his ability to perceive the incidents, as counsel is asking this court to do. He simply made a statement that, and again, it was asked on cross-examination in a playful manner. And so when you take into consideration his prior testimony that he had given and the times that he had spoken prior to even testifying in court, it is clear that he saw this with his eyes through the crack in the door.
Any other questions? Thank you.
Thank you.
The appellant has 3 minutes.
Thank you. Initially, as a matter of record clarification, TM is the first one who brought up being a robot on cross-examination. Defense counsel asked, "You said you can scan?" He says, "Yes." "What does that mean?" TM starts talking about robots.
How old was this child?
What's that?
How old was this
At
child?
the time of trial, I believe TM was 7. I mean, the record will speak for itself, but I'm fairly certain.
7.
Um,
How do we know he wasn't playing?
if he was, that's a problem. If he can't sit down-
That's the difficulty I have with this argument. And I see these and can't see the expression on his face. Did he have a glint in his eye? Was he smiling when he said this? I have raised 2 boys and they said all sorts of things when they were 7 years old.
Sure.
They were playing. Wasn't in a courtroom.
Yeah, no, that's the problem. And we talked, or not, Kansas Supreme Court talked about this in Ray Bowman, is that building trial testimony around live children is a risk. That is a risk the state assumes because they have other options. They can file a sync case, get a protective order, and consider refiling charges when the kid's closer to 10 and can meaningfully participate. But when they assume that risk, they accept the consequences. And the consequences here are the state presented a witness who, by their own admission, cannot sit still and testify truthfully and tell the difference between truth and imagination. That's a problem, and it needed to be corrected below.
But you haven't argued this issue as the court's failure to conduct a competency hearing.
That's correct. That might be an issue available on 1507. I do think for that, there would have needed to be an active objection and a motion for mistrial from counsel. I raised it the way that it was presented because it is an error that is presentable on direct appeal, and so that is how I've raised it.
I'd like to revisit Deha for just a second. So when I asked your opposing counsel, she characterized the officer of the court's involvement on the coaching issue as basically saying, this is a defense position we have, not that, Judge, I'm notifying you of active coaching. Do you agree with that characterization?
Oh, not at all. No, this was directly, the defense attorney told the court the presence of the mother, that this mother had coached this child. The presence of the mother would just reinforce what we believe to be a coach statement rather than the truth. It would very likely influence the validity of the testimony.
But there were no observations that they were basing that on. That was their defense position. But I'm saying, was there a point in trial where defense counsel said, Judge, we need you to investigate. We think there's coaching going on?
That's, I mean, that's the purpose of the objection. I guess they didn't say the word investigate, but no, we're not, I guess to clarify, we are not worried about there being active coaching going on during the trial. Frankly, I'm less concerned about that as a general matter because the jury actually sees that, and then that impacts the credibility of the witness. What we are worried about is the mother coercing these children into engaging in false testimony in the CAC interview and on the stand. That's what we brought up. That's what needs to be investigated. So I know the state argued that they applied their discretion in conducting the Rochelle factors, but that's conflating the issue. There wasn't a Rochelle error. There was a Dayhuff error. Once coaching is brought up before the court, they have a duty to investigate and ensure two things. One, which doesn't really apply in this case, is did the coaching have an impact on how the jury perceived events? The other is, did that witness's testimony become influenced by the individual's actions? That is something the court needs to look into. It's particularly important in these types of cases because children are more susceptible to being influenced by their parents than your average witness.
Did the CAC witness testify to a couple signs of coaching?
Yeah, absolutely. There was, so the CAC interview talked about, there's three major signs of coaching that we look for. Two of them were present in this case, which is inconsistency in the victim. We know that there were, which by the way, this refutes what the state said at the hearing of one recantation. There were 4 times to 4 different witnesses that LM recanted at least in full or part her statement. The other is the inability to give sensory details, the things that you would see, feel, hear, or touch during the event. And LM wasn't able to give any of that during the interview with the CAC interviewer. In fact, went silent whenever that opportunity presented itself. The other instances of coaching we can see through TM's testimony. He repeatedly said, and by the way, it's telling that the mother wasn't sitting next to TM when he was saying this, that he'd forgotten everything, but that someone helped him remember. And it was his mother who helped him remember it. And his mother told him what he needed to testify at trial. That's coaching. LM's mother scolding her when she recanted. That's coaching. That's the type of evidence that would have been uncovered had the court followed procedure. And at that point, then we could get into abuse of discretion land. Right now, we're at error of law. Unless there are outstanding questions, I would ask this court to reverse, and thank you for your time.
Thank you. Thank you both for your arguments today. We will take this matter under advisement and issue a decision just as quickly as possible. Thank you.